Ladies and gentlemen, I welcome all to my channel. Today we are going to discuss how to handle cheque bouncing case and how to escape from cheque bouncing case legally. So this video will be useful both to complainant and to the accused who will be facing the cheque bouncing criminal case. Now let us see what is meant by cheque bouncing case. There is an act called Negotiable Instrument Act in which section 138 says that when a cheque is bounced due to insufficient funds, then it will amount to an offence for which the court may impose fine to the extent of twice the value of the cheque and also imprisonment for a period of 6 months, it seems. Cheque bouncing is considered as a criminal offence as per the Negotiable Instrument Act. As far as the criminal offence is concerned, there is a general rule. Mere act will not amount to an offence. There must be various ingredients, various acts, involvement to constitute an offence and for punishment. Normally, intention, preparation, attempt and commission are the 4 stages of the offence. So if a person commits without any intention, in most of the cases, it will not be considered as an offence. So in order to constitute an offence, these 4 elements, intention, preparation, attempt and commission are required for the general offences. Likewise, for a cheque bouncing case also, the Act stipulates certain conditions, certain procedures, and once you fulfill all the procedure, then only it will be considered as a cheque bouncing case. So supposing a person issues a cheque and it is bounced, can you go to police station and give a complaint? No. The answer is no. You cannot go to the police station to make a criminal offence for the cheque bouncing case. It is a private complaint. We have to make a private complaint before the concerned court. Concerned magistrate court, you have to go to the court and file the case. Secondly, before going to the court, you will have to follow certain procedures. Just because a cheque is bounced, it will not amount to an offence. You cannot ask the court to give a punishment just because of a cheque bounce. So there are series of acts, series of requirements stipulated under the Act, and this procedure has to be followed. And if the procedure is followed, then only the court will take the cheque bouncing as an offence. So what are the procedures? Number 1, the cheque should have been given for a valid consideration. That means, if you purchase a property, purchase any material for which if a cheque is issued, then it will be called as a cheque issued for a consideration. Supposing you give a cheque to a married couple as a gift, or supposing you give a cheque to your relative as a gift, here there is no consideration at all. So in such circumstances, if the cheque is bounced, you cannot take it as an offence because there is no consideration for issuing such cheques. So in order to make the cheque bouncing as an offence, the first element is, which is required in law, is there must be a consideration. The check the checks must have been issued towards to discharge the consideration, to discharge a duty for a consideration. So if your check is issued for purchase of property or for a discharge of loan or for any other obligation, then and it is bound, then that check return can be considered as an offence under section 138 of the Negotiable Instrument Act. The second thing is, just because it is bound, you cannot go to the court. Now, once the check is bound, then you will have to go to you will have to issue a notice to the drawer of the check, stating that you have issued this check and it is returned as if really insufficient fund, or returned due to any other reason. This may be signature different, number amount not tallies, it is just something is striken, or anything, any other ground. And immediately after the issuance of this return of the check, the who record the check should issue a notice, demanding the drawer of the check to make payment within 15 days from the receipt of the notice. Now, the person who got the check, once the check is bounced, they are allowed to issue a notice within 15 days. Suppose you present the check. Supposing before that there is one more element is there. The check should have been presented within 3 months from the date of issue of the check. That is also one of the elements required to make it as an offence. So supposing if a person has issued a check today, January 1, if he issued a check today, 1st January, and you keep the check for about 1 year or 2 years. Now, after 2 years, if you present the check, then the accused will easily establish that I have issued a check 2 years back and it was not presented within 3 months, within the validity period. So it will not amount to an offence. Like what, he can defend the case and the court will also accept his defense plea. So in order to make an offence, the check must be presented within 3 months. That is number 2 element. Number 3, once the check is bounced, then the check you will have to issue a notice to the other party or to all the person, demanding them to make payment for the dishonored check value within 15 days from the receipt of the notice. Once he receives the notice, he has 15 days time to make the payment. Supposing within the 15 days he makes a payment and he settled the amount, he sent the DD or any other adopt any other method and pays the dishonored check value, in that case it will not amount to an offence. So the third element is we have to issue a notice and the person who issued a check should fail to make payment towards a dishonored check within 15 days. Once he failed to make payment within 15 days, then the person who received the check should file a criminal case in the concerned magistrate court within 1 month from the date of default. That means, supposing you issue a check first day of January, and you present the check on 2nd day of January, and it is bounced on 5th, then you will have to issue notice on 5th within 15 days from the date of dishonor. That means once the check is returned on 5th January, you will have time till 20th January. Once you issue a check notice, if he received it on 10th January, he has time to make payment for 15 days. So if he received a notice on 10th, he will have time till 25th January. So once he failed to make the payment on 25th January, you will have to file a case within 30 days from the default. That means from the 25th January to 25th February. So the case should be filed within 1 month from the date of default. That is before that is, if a check is, if the default period is on the default date ends on 25th January, then within 24th February, the case should be filed. So these are all the elements which required in law to make an offence punishable under 138 of Negotiable Instrument Act. Suppose if the complainant, that means the who received a check, failed to do any one of these elements, failed to comply any one of these elements. Suppose there is any violation or there is any one of the requirement is not properly fulfilled, then the accused will take that as a defense, saying that this check is not issued on, this check was for consideration. It was issued only for security purposes, or it was issued for only for as a gift. It was not issued for any valid consideration. Like what, he can take a defense. Then he can take another defense saying that the check, I have issued a check in January and he has presented a check in December, when it was not presented within 3 months period. Like that, he can take a defense. Again, he can also take a defense saying that he has not issued a demand notice of immediate within 15 days from the date of dishonor. If it is not complied, then also the case will go out. And if he files a case and the case is not filed within that 1 month period from the date of default, then that will also amount to that will also be a good ground to the accused to escape from the criminal liability. So these are all the first, whatever what we have stated first, are all the requirements to make the check bouncing as an offence. If any one of the element is absent, or if there is a violation in any one of the requirement, or if there is any default, otherwise if there is no non-compliance in any one of the element, then the accused can take this as a defense and come out of the case by filing discharge application or by filing quash application, or at least conducting the full trial. So these are all the defenses available to the accused to come out of the case legally, and these will be the legal grounds to the accused. Now, one more questions maybe you may ask, that is that called supposing a company issues the checks. Suppose ABC company issues the checks. Now, for the company, all directors are responsible. So you can file the case can be filed as against all the directors. I have one experience. One of my client got a check from a politician who is in Andhra. He was a chief minister, not chief minister, he was a very prominent minister, holding powerful portfolio in Andhra Pradesh. So when my client, who is doing a lubricating oil business, got the check bounced and issued a notice, then that politician who is in Andhra claimed that we cannot do anything, and he simply said that you have nothing to do. Even if you get a warrant or any, Andhra police will not do anything. Like that, he questioned he has threatened my client, saying that you cannot do anything. I am a powerful person, I am a politician, I am in Andhra Pradesh. Like that, he has claimed, he threatened my client, and my client also not in the fear that he cannot do anything. Like that, he felt. So what we did know, we just inquired the register of companies and got the details, saying and found that all his sons, daughter-in-laws were included as were directors in that company for which the check was issued. So immediately what we did now, we issued a notice to all the daughters, son-in-law, daughter-in-law, who are all directors of that company, and once we issued a notice and once we filed a case in the court, and also we have sent a note, summons from the court to all the daughters, daughter-in-law, son-in-law and sons who are all directors of the company. Immediately that family members put pressure on them, and they came and settled the amount in the first hearing itself. So when, likewise, suppose a check was issued by a company, you can file a case not only as against the company, you can also file against all the directors of the company and also all the persons who are in charge of the business, who are actively participated in the business, who are responsible for the issuance of check. You can file cases as against all the persons, so that it is easy for you to recover your money from the company to who issued a check. And another thing is that the object of cheque bouncing is nothing but to recover our money instantly, quickly, without approaching civil court. So once upon a time, cheque bouncing was not an offence. So when most of the foreign countries insisted India to pass necessary legislation to make this as an offence, and accordingly to safeguard the commercial interest, Indian government also passed this act. So, though it seems to be a civil in nature, as per the Act, the cheque bouncing, Section 138 of the Negotiable Instrument Act, the cheque bouncing is considered as an offence for which the court can impose punishment, fine, or both. Normally, the court, when I conduct the case, the court may impose. Most of the judges are imposing a meager fine of 5,000 rupees or meager fine of 5,000 or meager imprisonment, because it is purely a civil in nature. The act of cheque bouncing is purely civil in nature. However, when the person purposefully refuse to make payment, in that case, the court gives heavy punishment. In one of the actual, as far as the punishment is concerned, it is purely discretionary on the part of the judge. He can for one person he can punish 1 day imprisonment, or one person he can give 6 months imprisonment, or one person the judge may give 5,000 as a fine, or one person the judge may say what is called twice the value of the check. These are all the discretionary power available to the judge. In one case, what happened? She was an actress. A cheque bouncing case was filed by a company. I don't know what they don't know. They have influenced the judge in one way or other. In that case, the judge find the case as guilty, find the accused guilty, and give an imprisonment saying that 1 day. And he has to, the accused has to sit in the court for for 1 day, and the judgment was delivered at 5 o'clock, and the court closed by 5:30. So the accused was asked to sit in the court for only half an hour, and this half an hour sitting was considered to be a fine to that actress because of their influence. So, even if the judge did not give such rigorous punishment, record punishment, the aggrieved party can take the matter and appeal to the district court or to the high court and ask the judge to ask the appellate authority or appeal court to give additional appropriate punishment to the accused, supposing the proper punishment was not given at the lower court. And another thing is, what really happens in the cheque bouncing cases. So, once the cheque bouncing case is filed in the court, supposing the accused against whom the cases are filed, you are in a capable position. they negotiate with the opponent party and arrives for a settlement and make the payment. Suppose the cheque bouncing case is filed for 10 lakhs, the other party will come forward and say, sir, I can give only 5 lakhs or 6 lakhs, 7 lakhs as a settlement amount, and the parties and advocates mutually discuss with each other and arrive for a settlement. In many of the cases, what really happened, the bank people or the person giving the loan collect this check as a what is called as a security for security purposes and files a case behind the back. In such circumstances, in most of the cases, the accused are not in a position to make payment, or they do not have any means, any money. So, supposing the accused do not have any money to settle their check amount, or suppose they are not in a position to engage an advocate to contest the case. In most of the cases, the accused are running out of the residence and they abscond. Once they abscond, now the burden is on the complainant to bring him to the court. Supposing in a cheque bouncing case, the accused against whom the case is filed did not come to the court in person, even after the receipt of this summons, the court will only issue warrant. This warrant will be issued by the court to the concerned police station where the accused is residing. Supposing the case is filed in Egmore court and the accused is in Trichy, then the Egmore court will issue a warrant to the Trichy police station to arrest the accused. Supposing that accused was residing in that place, the Trichy police will go to the concerned place and took the accused on custody and bring him before the court and hand over the accused to the court. Supposing he is not there, suppose he absconded from Trichy and went to some Andhra Pradesh or some any other location. Now, the court will not be in a position to arrest the accused. See, in such circumstances, the court will direct the complainant who has filed a complaint to find out his address, to find out his whereabouts, and to get proper summons to the concerned police station where the accused was residing. So, in such circumstances, supposing the accused abscond from his original place, now the burden is on the complainant to find out the whereabouts of the accused, and then once he has to find out the things, and then he will have to, after finding out only, he can report the court that the accused is residing in so and so location, and he can request the court to issue some warrants to the so and so police station. Suppose he is not able to find out the location, the court will give 1 or 2 months time or 6 months time or 1 year time. If during this time the complainant has to find out the whereabouts of the accused and he has to report it to the court, and he will have to get a warrant to the concerned police station and to arrest the accused. So the burden is totally on the complainant to take all steps. The police will not take the responsibility, the court will not take the responsibility. The entire responsibility falls on the heads of the complainant. So in many cases, what really happened now, supposing the person is not in a position to make payment, they simply absconds. They simply absconds for 1 or 2 years period or 3 years period. During this period, if the court will not prolong the case indefinitely, so the court will, if adjournment is taken today, the court will next year the court will ask the complainant to get the correct address of the accused and to execute the warrant. The court will give 5 or 6 opportunities, and if his complaint is not able to produce the accused address, automatically the judge will dismiss the case, saying that the prosecution has not, the complainant has not taken necessary required steps to to arrest the accused. Like what, the case will close. The case will be closed. This is what happening in many of the cases. In other cases, supposing the person is residing in a particular place and he is in a well-to-do position and he is running a job or he is having any property, then he cannot escape. In such circumstances, those parties are automatically voluntarily coming to the court and engaging advocate, and they are trying to contest the case. If they are not able to contest the case, they go negotiate with the complainant and arrives for an amicable settlement. So, as far as settlement is concerned, case can be settled in the original court, there is a trial court, or in the appellate court. Supposing if you want to contest the case, you have a good case, and you don't want to compromise, you can contest the case. If you have good defense, you can take the defense, and once the judgment is passed, saying that you are suppose the court finds that you are guilty, the court will give you imprisonment may give you imprisonment for 1 month, and the court may impose a fine, against which you can file an appeal to the appellate court, and you can also file an application to the concerned court for a suspension of sentence, suspension of the punishment. So just because the judgment is delivered, automatically the accused need not go to the jail. So under circumstances, you can apply for supposing the court judge pass any judgment and impose any punishment, you can file an application for suspension of sentences, and then we can file an appeal to the district court or to the high court, and during that period also you can negotiate with the opponent party and make a settlement. As far as the criminal court is concerned, most of the cases the judges will give punishment for imprisonment or fine, and out of the fine, in some cases the judge will give a direction saying that out of the fine amount collected, some amount has to be given to the accused, complainant. So this cheque bouncing case is not a case to recover the money. Here in cheque bouncing cases, we are only asking the court to give punishment. So even because of this punishment threat, they automatically come forward a compromise and settle the amount. So this is the thing going on in cheque bouncing cases. So as if you are a complainant, if you have filed a case for a cheque bouncing case, and if you are able to recover the money within a period of 3 months or 6 months or 1 year, 2 years, it's okay to you, and you can collect the amount and you can close the case. Suppose the accused is not in a position to make a payment and is prolonging the case, then you will have to make a civil case also. Otherwise, as far as suppose the cheque bouncing in the cheque bouncing case, the court may finally give only punishment to the accused. The court will not pass any order saying that you will have to make payment to you, or the court will not give any judgment in your favor saying that the opponent will have to make payment to others. Here only a punishment is there. So, if the person says that I will not make any prolong the case, then you will have to file a civil case. So, filing there is a limitation period. Is that 3 years is the limitation period to file a civil case. So, if the cheque bouncing case is prolonged for a period of 1 year, 2 years, then it is advisable to file a civil case also. In civil cases, you can file a case, civil suit, and claim not only the principal amount, you can also claim interest and other court fees and other expenses through which you can safeguard your interest. I hope this video will be useful to both complainant and to the accused, as this will give a clarity how to conduct the case and how to take a defense and what are the defenses available to the accused to come out of to escape from the criminal liability. So you may watch my channel and you can gain your knowledge. We have posted a lot of videos in this channel. You can select any one of the topic and you can clarify your doubts and you can acquire legal knowledge. Knowledge is power. Legal knowledge not only give you the power, it will also give you the confidence, strength in your life. In addition to that, if you have any clarification or doubt or otherwise, if you need any legal opinion, you can also contact us. We can also give you the required legal consultation depending upon your requirements. I hope this video will be useful to you, and you can also share this video to your friends who needs clarification on this subject. I will come again with another topic. Until then, goodbye. Raziaq Ali.